All right, folks, it's time for our favorite podcast, Cut to the Chase. As you know, last week I covered a lot of the new legislation in Florida, personal injury stuff, and I would be remiss if I did not bring Dylan Barket on, who does personal injury himself, but also specializes in landlord-tenant law. And I know there's a lot of tenants out there that get taken advantage of in Florida. And this is the guy that can help you even the playing field. And from what I've been told, there have been some, or at least one change in the law in terms of security deposits. So we're going to do a rapid fire session with Dylan Barket, who's busy at work right now, but he's taken the time to come help educate our audience. Dylan, how are you doing?
I'm doing well, Greg. So just a rapid fire, HB 1417. It's kind of a myth. It doesn't actually amend the security deposit statute. There is some stuff in the works that a landlord will be able to charge you a monthly fee rather than a security deposit. So you don't have to pay the security deposit, but you'd pay a non-refundable monthly fee. The idea is if you can't afford the security deposit, your landlord could basically break it down by the month, but you do not get that money back. It's not like a regular security deposit where if you don't damage the unit, you get it back. It would be totally for the landlord to keep.
Yeah.
But kind of diving in, this is probably the most pro-landlord bill we've seen in the state of Florida. It totally overrides and preempts counties from any sort of landlord-tenant law. So, for example, Miami-Dade County, they have a landlord-tenant. They call it the Tenant Bill of Rights, preempts that. They have a Bill of Rights that the landlord is supposed to give to the tenant to have them fill out, preempts that. They require 60 days notice of a termination on a month-to-month tenancy. It preempts that. It cuts the time period only to 30 days. Currently, it's 15 days. It raised it from 15 days to 30 days. So it kind of preempts a lot. I mean, it's preempted just about everything. The power is entirely with the state now. It does give you those 30 days, but, not really pro-tenant considering Miami-Dade County was requiring 60 days. It also preempts, the notice in Miami-Dade County currently. If the increase of rent is 5% or more, you're a month-to-month tenant, you need to give 60 days notice. It's preempted that. So basically it's sent everything back to the state. It's, a really clean cut, 30 days, month-to-month tenancy. They can cut you out in 30 days. That's pretty much what it does. And basically says that the county does not have the power to make these local tenant rules, local tenant regulations. I think it's entirely pro-tenant, or I'm sorry, pro-landlord. Not really fair for the tenant.
Yeah.
I think it's a lot easier, for example, in a place like Lee County or Leon County in Tallahassee, Florida, to move in and out of an apartment within 30 days. I think it's a lot harder in Miami-Dade County where you have HOAs and they want to approve every single tenant that comes in. You have condominium associations who, again, need to approve the tenant. You have a lot of competition for housing. You have apartments going for above market rate. Makes it a lot difficult, or a lot more difficult, for a tenant to basically secure it. So my advice to tenants would be plan early and plan ahead. They only have to give you 30 days notice now. If they're not planning on renewing your lease, that's something else. The Miami-Dade County used to say 60 days notice. It's only 30 days notice by state law now. They can give you up to 60 days notice, but no less than 30 days notice. So, kind of a home run for landlords and a strike for tenants.
Big bummer for the tenant. So in terms of the security deposit, if you do pay a security deposit, that's still refundable. The law didn't change.
The law has,
if you're doing this month-to-month payment.
Exactly. Well, if you have a security deposit, the law is the same. If you have a security deposit, if they're intending to make a claim, which means, withhold any money, 1 cent of that deposit, they have to let you know within 30 days of the tenancy ending or you vacating the unit. If they're not intending to make a claim, it has to be within 15 days. And here's the big catch. This is where a lot of landlords make a mistake. The notice has to be by certified mail. If the notice is not by certified mail, the tenant automatically wins. It's a clean cut motion for summary judgment argument. The statute says via certified mail. It's got to be by certified mail. So keep the envelope, because if you could show that your landlord didn't send you that letter by certified mail, you win automatically.
You win. So even if you get the letter, regular mail and email, and they deliver it to you in person, it doesn't count. That
Doesn't count
has. All right. So listen, folks,
by certified mail.
right? So if you want your security deposit back and they're withholding it and all that, do they have to pay you to represent them, or does the landlord end up paying you?
Well, it depends. Some attorneys, it's hard to find tenant attorneys, but the most important thing I tell to a tenant is, if you're moving out, step one, text, email, call your landlord, put it in writing, your new mailing address, because then they have an obligation to send the security deposit withholding letter to that new mailing address. If you don't tell them, they can send it to the apartment or house that you just vacated, and you're on your own. You only have 15 days to object from when you get the letter. So it's important to tell them. But yeah, a lot of attorneys charge for these security deposit disputes. They're hard to come by, tenant attorneys, but I don't charge. I'm always willing to look over your case and either point you in the right direction or sign you up as a client against your landlord. And if we win, we prevail. And, I would always give you the odds. I can never say 100%, but a lot of these are very clean cut. My last one, most recent one, they charged the couple, it was a couple, $1,800 to quote unquote wash the walls. Yeah, we won that case. I mean, clean cut. Not only do the security deposit withholdings have to be reasonable in nature and expense, meaning $1,800 to clean the walls, really. They also charged $150 to clean the grout in the tub. Come on, that's not reasonable in nature or expense. But they also have to be not related to regular wear and tear. So, your landlord says, the floor is a little scuffed. You lived there for 5 years. That's wear and tear. So things to keep in mind.
Thank you for your update. If you are a tenant and you are like, hey, where's my security deposit? Don't wait. Give this man a call. I'm going to put his information in the show notes. But Dylan, what's the best number to call you in case somebody is not looking at the show notes and they're just listening here?
Call our office, 305-373-6711. Ask for Dylan. Tell him it's a security deposit dispute and that your landlord wants to keep your security deposit and not pay you.
All right. Thank you for coming on this short notice, but everybody take care out there. I know it's a rough patch of time, and everybody's trying to squeeze you for $1, and it's getting hard to find good quality attorneys. Dylan does this landlord-tenant stuff. Nobody else is representing tenants as far as I know. And I've been doing, civil litigation for decades. I wouldn't say a century, but decades. Dylan, thanks for coming on. And we'll, the next time we got another tenant issue, you're our man. All right.
Thanks, Greg.
All right. That'll do it for this episode of Cut to the Chase. Subscribe, rate, review, questions. You got questions for this good looking guy over here, young up and coming attorney who does not only this kind of stuff, but personal injury stuff. Let me know and I'll let him know. Or you just can call him at the number that he gave you.
Thanks, guys.